Would you like to commence your application, please?
Yes. Good morning, Master. My name is Imran Nauth from Collows LLP. I am representing the client in this matter, Nesbo Gas PLC. And may I equally introduce my colleague for the defendant, Mrs. Sophie Wellington from Swallows and Company, who is representing the defendant, Ezra Gases Calcutta Limited. Master, this is an application by the claimant for a summary judgment. Master, have you received a copy of the bundle?
I have, yes.
Thank you, Master. Master, my submission to this court is regarding a breach of an express term or breach of express terms in the joint venture agreement. I shall be referring to this agreement as JVA henceforth. The defendant's position, the defendant is contesting this notion, saying they are no longer held liable under this agreement due to some unfolding events in the London Stock Exchange, the details of which I'll be submitting to this court for your consideration. Master, would you like me to summarize the facts of this case?
No, that's not necessary. Thank you.
Thank you. Master, the claimant seeks summary judgment on the basis that the defendant has no real prospect of successfully defending the case and at a trial. Sorry, Master, the claimant seeks summary judgment on the basis that the defendant has no real prospect of successfully defending the claim at trial, and there is no other compelling reason why the case should be disposed of at a trial. Master, there are two issues that need to be considered today. Firstly, was it an express term of the joint agreement that the defendant should indemnify my client, the claimant? And secondly, if there was such an express term, was it in breach by the defendant? Firstly, was it an express term of the joint venture agreement that the defendant should indemnify my client? May I refer you to the witness statement of Herman Meyer, which is at page 14 of the bundle, please? Yes. Herman Meyer is a chief executive officer of the Claimant company. On page 14, paragraph 4, he had a good relationship with the late chairman, Sir Lancelot Ezra, who is the father of the current defendant, which is Paul Ezra. And since the 1970s, that's almost 50 years now, they did many deals, and then come the JVA, the joint venture agreement. Master, on page 6, on paragraph 6 of page 15 of the same document, my client reckons here that he will provide the funds via the bank as a guarantor, and they will provide technical support. In exchange, they will upgrade the defendant plant and gas pipes lines. At paragraph 9, at no time did the claimant agree to ignore clause 19b, which is the main contention in our case today. To agree to vary clause 19b as suggested by the defendant would have struck at the heart of the JVA. And in paragraph 12, it was always my client's priority to honor this JVA, and my client did not terminate this so as to give rise to the defendant reaction of stopping all payments to the bank and sending a solicitor's letter. Master, may I now take you to the joint venture agreement on page 6 of the bundle? This agreement is made on the 16th of May 2018 between my client Nesbo Gas PLC and Ezra Gases Calcutta Limited. Paragraph 19 states, Nesbo Gas PLC agrees to act as guarantor of any loan provided to the defendant for the purpose of funding his JVA. And at clause B, Ezra Gases Calcutta agrees to indemnify Nesbo, which is my client, for any sums it pays under this agreement. Master, was this an express term of this agreement? Of course, because it is part of the foundations of this joint venture agreement. So By refusing to indemnify my client, Ezra is in breach of this agreement according to clause 19b. Secondly, Master, in relation to this first issue, the defendant has no real prospect of successfully defending this issue at the trial. Secondly, if I may, I will address you on the second issue, namely, if there was an express term in the JVA, was it breached by the defendant? Master, may I refer you once more to page 6 of the bundle, which is the joint venture agreement. At paragraph 19, clause B, Ezra Gases Limited agrees to indemnify, which is an express term of this agreement. So the defendant stopped the payments from the bank, and my client honored and fulfilled the clause A of this joint agreement. The defendant was asked to indemnify the full sum as per 19b. The defendant then refused to do this, and therefore he's in breach of this. The claimant requested the defendant to indemnify the full sum of 6,322,440, which was the outstanding balance at the time they stopped paying the bank. So because they've actually relied on the reason why they've stopped the bank payment is that they have relied on the sources that on the London Stock Exchange. And then they sent a solicitor's letter dated 13th of April 2022 to affect this breach, which can be found on page 18 of the bundle, while relying on an external wrongly interpreted and misconstrued definition from an announcement by my client on the London Stock Exchange on page 9 of the bundle. Master, to point out here, these two documents, the London Stock Exchange news and the solicitor's letters, should be understood, should be read together in terms to understand the reasons why the defendant actually breached this agreement of clause 19a. Master, may I take you to the London Stock Exchange announcement firstly, then I will take you to the solicitor's letter. May I take you to the announcement on page 19 of the bundle? Now, London Stock Exchange market news dated 13th of April 2022. Nesbo Gas PLC announces that it is terminating its joint venture agreement with Ezra Gases Calcutta Limited, signed in May 2019. Now, Master, the underlying word here in this agreement is the term terminating. Now, terminating is a future continuous tense. My client did not say they have terminated this JVA, so they have misconstrued and misinterpreted this word. By relying on this, they have then angered them, and they have then sent a solicitor's letter. May I now take you to that letter on page 18 of the bundle, please? Now, Master, in the second paragraph, the solicitors are saying we refer to the joint venture between my client and the defendant. And in the third paragraph, they're saying, today you have announced on the website of the London Exchange that you are terminating. Here again, in this document, they have relied on that announcement, and they said, as a result of this, our client will be released from all future obligations. Now, this letter is evidence that the defendant has given us confirmation of this breach. They have relied on an announcement on the London Stock Exchange. This is another important development in the issues, and the fact that the defendant own evidence supports this claim in the respect of this breach of clause 19b. So the defendant and his solicitors have breached this clause 19b by writing us this letter. Master, they have both interpreted it, like I've explained to you, the terminating wrongly, and my client have never given them any termination letter. The intention, that was just an intention to maybe this was done at the time when the defendant's shares profit, the shares price were dropping on the stock exchange. So to avoid future liability or companies relying on my client's credibility, because like I've outlined to you in the statement, my client has been with the defendant company for more than 50 years, since the 1970s. Now, the next point I would like to draw to your attention, Master, is another important is I wish to draw to your attention is the meeting of the note, the meeting note, which is the 19th of June. In this meeting, Mr. Ezra, who is the defendant, he at the paragraph 4, he says, it was understood that the clause was there for the comfort of the bank. Now, Master, if we were to construe or interpret that, that means that my client would have done a very unjust enrichment and proceeds of crimes. So I advise the court to dismiss this matter. Master, to conclude on this matter, my client has been a very long, outstanding professional individual. He has acted in very professional capacity with integrity. He would not terminate this contract unless he would given 6 months notice in lieu of the agreement. Master, considering all my submission I've presented to this court today, I can submit to you that the defendant has no real prospect of successfully defending these issues at trial. Master, you'll be familiar with the provision of CPR 24 2A and 2B. This gives you the power towards summary judgment for the claimant as a matter of your discretion if you satisfy that the claimant has discharged his burden of showing that the defendant has no real prospect of successfully defending this claim at trial, and there is no compelling reason for the case to be disposed of at trial. Master, I submit that the claimant has discharged his burden. The claimant has shown that this express term of the JVA has been made clear, and I've done everything to honor this. The documentation presented for your consideration clearly confirms this fact, and nowhere in the witness statements nor any of the other documents there was any substantial evidence that the claimant did not honor this JVA. Further to the Master, accordingly, I ask you to enter summary judgment for the damages to be assessed. Unless I can help you further, these are my submissions. Thank you.
Thank you, Mr. Nauth. Just bear with me one moment while I gather my